Welcome to The Explainer. I am absolutely thrilled you're joining us today because we're going to unravel a fascinating and honestly quite bizarre historical mystery. We're looking at a legal system that completely defined the lives of half the population for literally centuries, and yet it operated almost entirely in plain sight. It's a framework that governed everything from classic literature to global economics, and it all starts with a very simple, seemingly impossible math problem. So what does 1 plus 1 equal? Well, if you learned basic arithmetic, you'd obviously say 2, right? But under historical English common law, specifically when we talk about family law and marriage, the answer completely defies the basic laws of mathematics. Any guesses? The answer is 1. Yep, 1 plus 1 equals 1. As United States Supreme Court Justice Hugo Black famously pointed out centuries later regarding this exact legal fiction, this rule has worked out in reality to mean that though the husband and wife are one, the one is the husband. Okay, let's dive into this. What we're talking about is the Doctrine of Coverture. It was essentially an invisible legal cage that merged a woman's entire existence into her husband's the moment she said, "I do." To really grasp how deeply this shaped our history, here's our roadmap for today. First, we'll hit the math of coverture and the harsh legal reality behind it. Then, we'll see how it fueled the high-stakes marriage market of Jane Austen's Regency England. After that, we'll track its massive global footprint, and finally look at its agonizingly slow unraveling. All right, let's jump straight into Section 1, the legal reality, where identities literally merged. To understand how 1 plus 1 equaled 1, we actually have to trace English common law way back to the High Middle Ages. That's where the foundations for merging two separate identities into a single legal entity were first laid down. The defining principle of coverture was laid out most famously by the jurist William Blackstone in his 18th century commentaries on the laws of England. His definition really captures the core of it. Upon marriage, a woman's legal existence was suspended, like literally paused. Blackstone wrote that she was incorporated and consolidated into the husband, placed entirely under his wing, protection, and cover. They called this the principle of unity of person. In the eyes of the law, the married couple became a single, solid entity, and that entity was controlled 100% by the man. And this created a really stark divide in society, neatly boxed into two legal French terms, the femme sole and the femme covert. A femme sole was an adult unmarried woman or maybe a widow, and surprisingly, she actually had distinct legal rights. She could own her own property, sign binding contracts, run her own business. But the exact second she got married, she became a femme covert, a covered woman. In a flash, her separate legal identity was completely erased. Now, think about the sheer scale of what was lost here. Marriage was, of course, culturally celebrated, but legally, it was a massive downgrade for a woman's autonomy. She lost the right to own movable property. She couldn't sign contracts or even keep the wages she earned herself. If she wrote a book, the copyright automatically passed to her husband. If she committed a minor crime, the court often just assumed she acted under his orders because legally she lacks individual liability. She couldn't even go out and get an education if her husband decided against it. So, you're probably wondering, how did people actually live under these extreme constraints? Well, to see this invisible cage in action, we move to Section 2, Jane Austen's marriage market. We're stepping out of abstract law and into the lived, breathing reality of Regency England. We so often think of Jane Austen as a pure romantic, right? Or maybe a proto-feminist rebel. But there's a fascinating paper from the International Journal for Multiplicity Research that completely challenges this. It argues that Austen can actually be read through an anti-feminist lens. Not because she disliked women, far from it, but because she was an incredibly brilliant realist. Austen wasn't writing fluffy fairy tales. She was actively documenting how coverture forced women to treat marriage as a strict economic necessity. She showed us that female survival didn't depend on overthrowing the patriarchy, but on successfully navigating its incredibly rigid rules. Take Pride and Prejudice, for instance. The entire plot is basically driven by the sheer, unadulterated panic of Mrs. Bennet. She famously laments that the estate is entailed away from the female line. And that perfectly captures it. Because of the laws of primogeniture and coverture, property bypassed women entirely to stay locked in the hands of male heirs. If the Bennet sisters didn't marry and marry well, they were looking at absolute economic ruin. Their frantic search for husbands wasn't just about finding true love. It was literally about survival. And nothing illustrates this pragmatic, high-stakes game better than Charlotte Lucas. She's Elizabeth Bennet's practical friend, and she just bluntly states, happiness in marriage is entirely a matter of chance. For women without inherited wealth, romance was a total luxury. Economic stability was the real goal. Yes, Austen's heroines usually find happiness in the end, but notice that they only achieve it by conforming to the system, marrying within or above their class, and accepting that deep economic dependency. But here's where the story gets even bigger. This idea of erasing a woman's legal identity definitely didn't stay confined to the English countryside. In Section 3, we're going to look at how coverture became a massive global export, hitching a ride on the expansion of the British Empire. The footprint of this legal doctrine was globally devastating. For example, in pre-colonial India, upper-class women could actually be zamindars, wealthy estate managers. But the East India Company was highly uncomfortable with female financial autonomy, so they actively restricted it, imposing a coverture-like system where a woman's religious and legal identity was just swallowed up by her husband's. In Lebanon, under various personal status codes, women faced a sort of civil death upon marriage, losing their voting district and even child guardianship rights. And in Nigeria, traditional Igbo law actually allowed women to own property they bought themselves, but colonial courts stepped right in and restricted that, enforcing the Western idea that a wife couldn't exit a marriage with anything more than her clothes and a few kitchen utensils. So this doctrine systematically stripped away financial and social autonomy all over the globe. Which naturally brings us to Section 4, the slow unraveling. Because dismantling an invisible legal cage that equates 1 + 1 to 1, that doesn't just happen overnight. It took centuries of painstaking, grueling effort. The resistance actually started pretty early on. In 1776, Abigail Adams wrote this incredibly famous plea to her husband, John Adams. She urged the Founding Fathers not to put unlimited power into the hands of husbands. She wasn't just talking about the right to vote. She was specifically begging for relief from the tyrannical structure of coverture. And how did John Adams respond? He essentially laughed it off. He wrote back, "I cannot but laugh." So the journey to dismantle this was agonizingly slow. We're talking late 1800s before the US and UK even started passing Married Women's Property Acts, which just gave wives basic rights over their own earnings. And astoundingly, it took until 1966 for the US Supreme Court to officially declare the institution of coverture obsolete. Think about that timeline. It wasn't until 1981 that the Supreme Court finally struck down Louisiana's head and master laws, which had literally given husbands total administrative control over jointly owned property. But even as the formal laws changed, the phantoms of coverture lingered deep into the 20th century. Since women historically couldn't make contracts, they couldn't hire divorce lawyers. That led to bans on alternative fee arrangements that still influence legal ethics today. Even darker, because a wife was viewed as the property of her husband under the 18th century Lord Hale doctrine, it was legally considered impossible for a husband to rape his wife. It wasn't until 1978 that a husband was criminally prosecuted for marital rape while living with his wife in the US. And until the late 1960s, courts routinely denied wives the right to sue for loss of consortium if their husbands were injured. Why? Because legally, only the husband had a right to the wife's services, not the other way around. And that brings us to our final section, Echoes of the Past. We really need to look at how this history connects to our lives right now. Coverture might be legally dismantled, but, institutions that last for almost a millennium always leave a footprint behind. So the crucial point I want to leave you with is this. Take a close look at modern marriage. When a woman traditionally takes her husband's surname, or when couples immediately merge all their finances into a single joint bank account, or even how society casually views the head of the household, are these simply harmless, romantic traditions, or are they lingering echoes, historical ghosts of a time when the law literally erased a woman's identity? Coverture might be gone from the law books, but the next time you look at modern family structures, ask yourself, have we completely stopped believing that 1 + 1 = 1? Thank you so much for joining me on this explainer. I truly hope it shifted how you see our history.